What is consideration in contract law? Consideration is a common law doctrine and is one of the foundational elements required for there to be a contract. At a basic level, a contract is often described as necessitating three ingredients: offer, acceptance, and consideration. In simple terms, if it can be shown that the offer and acceptance, or the mutual assent of the parties, is supported by consideration, then we will generally say that there is a valid and enforceable contract. In this video, we will be providing an overview of consideration as well as its implications for contract modification in the common law. So what does consideration mean in the common law? According to John McCamus, consideration consists of an act or forbearance or promise thereof given in return for the promise that one wishes to enforce. As we learned in class, there are three characteristics of consideration. 1, it must be something of value in the eyes of the law. 2, it must move from the promisee to the promisor. 3, there must be some detriment to the promisee or benefit to the promisor. Put otherwise, consideration means that there must be a bargain for exchange, whereby the promisee suffers a legal detriment of some sorts. The premise underlying the doctrine of consideration is the fact that the common law does not recognize bare promises, just as it doesn't enforce gratuities. Now, let's try to show this concept with a more concrete example. Say Tim offers to sell his car to Amanda for the price of $100. Amanda accepts. In this case, Tim is the promisor and Amanda is the promisee. Amanda is suffering a legal detriment in the value of $100. Moreover, this is clearly a bargain for exchange, as Tim's promise to sell his car to Amanda for $100 is inducing Amanda's promise to pay $100 in exchange for the car. In this scenario, the three criteria of consideration have been satisfied. Thus, we can conclude that this is a valid example of consideration. However, a quick look at relevant case law shows us that consideration is not always as straightforward as we've seen in the example of Tim and Amanda. In Hammer v. Sidway, an uncle promises to pay his nephew a sum of money if he agrees to refrain from drinking and smoking for a specified time frame. From this, we learn that if a promisee agrees to refrain from something to which he or she had a legal right, that constitutes a detriment and consideration is present. Moreover, in Stott v. Merritt, it is held that abstention from a legal right, including forbearance to sue, is sufficient consideration regardless of the chances of success of the legal claim. However, in White v. Blewett, where a father promised to give his son more money in exchange for him refraining from complaining about his inheritance, we learn that one cannot, in consideration of a promise, give up a legal right that he does not possess. In this case, the son does not have a legal right to an inheritance, and thus refraining from complaining about his inheritance, while it may be annoying, is of no value in the eyes of the law. Additionally, Stilt v. Myrick exemplifies the pre-existing duty rule, whereby a promise to do something that one is already bound to do is not valid consideration. Here are some other relevant cases to understand consideration and contract modification. From them, we know that a gratuitous promise, such as a conditional gift to use one's property, is not enforceable. In unilateral contracts, consideration is provided at the time of performance. The obligation must be coextensive if it is not implied. Consideration can be implied in the contract or inferred by the court. Where the defendant has secured benefits as a result of the price increase, in the absence of economic duress or fraud, there is sufficient consideration for contract modification. Promissory estoppel in the absence of consideration is contrary to the common law of contracts. However, that does not allow a party to act in an unconscionable way and stand by in silence while the other party relies on their promise. Extra wages for extra work does not exist in contract law for public policy reasons. In modifying a contract, fresh consideration must be provided. A promise intended to be binding is binding so far as its terms apply. A promissory note releasing parties from a previous engagement can serve as sufficient cause or consideration in Quebec.